All right, welcome. We have a few people jumping on the call and getting connected already. Welcome, welcome. We are going to give about 5 minutes to let people get connected and join before we start the presentation. And here in a few minutes, I'll give some house rules and share about the format of the evening. While we're waiting to get started, if you want to open the chat and share where you are joining us from, what state you're in, that would be great. I am in Ohio, lovely, luxurious Ohio.
I'm currently in Texas, which I'll say most of the time it is luxury and amazing, but
Yeah.
and our weather is cooling down. So
Well, that's good. It's usually super hot that like in the summer, like you're on the tail end of the heat, right? Like
yes. September, I know in most areas, September, everyone's like fall and fall weather, and it's amazing. Ours still feels similar to summer, but
yeah,
we have that cool breeze in the morning, and we all take advantage of that.
absolutely. Donna, how is it where you are?
I'm in North Carolina and it is nice and pleasantly, it's a little, cool. It gets cool in the evening. Still
Yep.
summer days, but cool evenings. So,
Yeah. We're starting to have that similar weather where we get the cool mornings and the cool evenings, but still hitting some pretty hot temperatures during the day. So yeah. All right. I know I can see some of the people in the waiting room or in the that are joined here, and I know a few of them where they're coming from, but definitely chime in on the chat if you'd like to share. Because this is a webinar format, you are going to remain muted as a participant. So the chat feature is how to connect with us. So please feel free to use that throughout the evening. We'll give it a couple more minutes and then we'll get things kicked off. All right. While we are waiting, I am going to go over just a few things for the evening. So again, a couple more minutes and then we'll get the presentation started. This is a webinar style format tonight, so everyone will be remain muted throughout the presentation. Please bring up the chat function or the Q&A function on your Zoom meeting. This is going to allow you to submit questions throughout the presentation. And after Brooklyn is done sharing this evening, we will have question and answer time, which I will moderate and share questions that you are putting into the chat for her to answer. If you need to connect with our team after the presentation, if you have additional questions or you're looking to get in touch with Brooklyn or a member of her team, we're going to have some information in the chat once the meeting gets started. So make sure you take that down. You can definitely reach out to us. All right, we're going to give it one more minute and then we'll get everything started here. I'm personally very excited about this topic. I was telling Brooklyn when we were doing our screen test and audio test that I put this on our internal agenda like 3 months ago and said, I think in September we need to have somebody from Byrd Adatto come and talk on this topic. And so very, very timely. So let's go ahead and jump in. I'm sure we're going to have some additional attendees jumping in here in the next few minutes, but I want to be respectful of everyone's time. Thank you everyone for joining us this evening for our Clarity After Hours webinar. We're really excited to have you all here today. And again, this is a really hot topic. It's something that's been on our radar for a couple of months now. But we're really excited to have Brooklyn join us this evening and share, because this is not just a hot topic, but I feel like it's an ever-changing saga, and we recently had some changes that you're going to get the most up-to-date information that she's going to share with us this evening. So I'm Lindsay Shaw. I'm the VP of Practice Development here at Clarity, and I'm going to moderate this evening's session. So please use your chat and QA function to share with us. And we have our presenter tonight is Brooklyn Townsend from Byrd Adatto law firm. Again, we're very excited to have her, and I am not going to steal any thunder. I'm actually going to turn it over and let her do a little introduction about herself and jump right into this evening's topic. So go ahead, Brooklyn.
Awesome. Thank you so much, Lindsay. And I'm very happy to be here tonight. Thank you all for having me. And I'm looking forward to spending this next hour or so together. And like Lindsay said, I don't think the timing could have been more perfect. You're going to get the most recent developments as it relates to non-competes and where they stand. I know just in my practice, this is always been a hot topic, even regardless of the new FTC rule. So I'm very excited to be here with you all and to dive right in. So as Lindsay said, my name is Brooklyn Townsend, and I am an attorney at Byrd Adatto. If you haven't worked with Byrd Adatto in the past, just a little background about our firm. We are a business healthcare transactional firm. And with that, we can dive into various different areas of the law, which can include anything from the healthcare regulatory compliance, corporate compliance and structure. And today here we have employment law. So it's really great for us at the firm that we get to dive into all these different areas of the law, because really when we do work with our clients, and I'll say too, we work with a lot of clients in the healthcare space, but we have a very special, niche area with the medical aesthetics space. So a lot of our clients are in the space. We're familiar with you and your business. And so with that, we get to work with our clients and growing and developing their business, or just starting or possibly selling. So that's why our firm gets our hands in all these different areas. But today we're going to have a little bit of employment law, and you'll see a bit of the healthcare aspect and the aesthetics area in there as well. So with all of that said, let's go ahead and get started. And just to on the onset or outset, I have no disclosures to make as it relates to this presentation. And so before we get started, I want everyone to kind of have an overview of where we're going to be headed this evening. And I know with the title and what's piquing everyone's interest, it's a lot about the FTC rule. But before I get into that and the status of where it's standing, I do want to talk about non-competes in general. I hear a lot of different things as it relates to non-competes, different definitions and what they could mean. So before we get into talking about them, I just want to make sure we're all on the same page terminology wise. And of course, then we'll cover the FTC ruling to have all of that, and you can understand the process and where it has gone since it was first announced last year. And then with that, this is where we're going to get into the little specialized area of the aesthetic medical industry and how that can apply to your practice. We'll talk about various different non-competes that may have limitations or restrictions in certain states. And then what's really important to you, and I know where a lot of the questions come from, is how do I implement this into my practice? How can I enforce it moving forward? And what if you are in a state that has never allowed non-competes, but you still want to protect that company information? We're going to get into all of that as well. Starting with our non-competes in general. Like I said, sometimes I can hear various definitions of what a non-compete could be, and this could either be coming from a conversation with an employer or with an employee. So setting the stage of what the non-compete is and why you would want to put a non-compete in place. So a non-compete is a legal agreement between an employer and employee that restricts the employee's services after employment. So my emphasis on after employment, the question I get most often is, oh, I think I have a non-compete in my agreement, or I'm enforcing a non-compete against my employee. Will you take a look at it? And oftentimes it is a provision that restricts their ability to render services elsewhere during their employment. So the key piece of that is during employment. That practice is very, very common. You bring an employee on, they can't go render services for a competitor unless you give them written consent. But that is going to be completely different from this discussion. Those types of provisions and restrictions are not going to fall under the non-compete regulations or statutes. So we're all good on that front. There are also various other types of restrictive covenants. So you can think of it as an umbrella with restrictive covenants on top, and then you have non-competes, non-solicitations, and non-disclosures falling within the umbrella. And so those are other types of restrictive covenants that we'll discuss later on in the presentation, but for our primary focus is going to be the non-compete post-employment restriction of competing against a former employer. And with that all being said, we'll move into these general non-competes and what might make this non-compete enforceable. And like I said, with terminology, whenever I am using kind of this enforceable quote unquote terminology, I'm talking, would a court of competent jurisdiction analyze and look at the non-compete that you have in your employee's employment agreement and determine, yes, this is an enforceable non-compete. So that's what we always mean. I know a lot of terminology. Oh, is it legal, illegal? Really, when we're talking non-competes, we talk about enforceable or unenforceable. And here, without getting into any of the specifics on a state level, these are requirements here that you will see in any state that allows a non-compete. These are going to be general requirements that are going to make your non-compete enforceable. And the first thing that a court's going to look to is, did the employer have a legitimate business interest in enforcing this non-compete against its employee? I'll say this is one of the easiest ones to meet. Typically, an employer's legitimate business interest can be shown by the fact that this employee has received confidential information. And I'll say that that's very easy to meet. Just being an employee, you know the ins and outs of the business, and confidential information can typically be defined to be quite broad. So the legitimate business interest of an employer wanting to protect their business, easy one to check off the list. The next requirement a court would look at is it reasonable? When you're talking reasonability, you have these three kind of areas here as we have on the slide. And the first one is looking at the scope of services. Typically, when you have a reasonable non-compete, the restriction post-employment is going to be related to the same area of services that they were performing for you. So if you have a nurse practitioner rendering medical aesthetic services, if their non-compete is limited to medical aesthetic services, that's a reasonable scope. That's not to say that a non-compete that just listed medical services and didn't qualify with the aesthetic piece, whether that would be deemed reasonable. It very well could be. It just depends on the practice. It also depends on the court that you're in, on whether they would find it to be reasonable. But really, it can be on a case-by-case basis. But if it said just, you cannot provide services within 10 miles, and that was it, it didn't qualify services, just anything, you can't be employed, that would be quite broad and probably wouldn't be found to be reasonable. The next piece in the reasonability is time. So absent a state statute or regulation that's very specific on the time period in which you can restrain this competition, you're typically seeing anywhere from 12 to 24 months. Those are pretty standard durations that will likely be upheld. There can be times that justify a longer time period. Did this employee negotiate at the start of their employment for a guaranteed 3-year term, meaning that that employee could not be let go without cause during the first 3 years of their employment? And so giving them that protection could justify a longer non-compete. It all, again, depends on the situation. And then lastly, it has to be reasonable in its geographic scope. This can vary depending on where you're located. So if you're in a more metropolitan area like I am, I'm currently in Dallas, Texas, my geographic scope to be found reasonable is going to be smaller. Because if you think of the area, we have plenty of medical practices, plenty of plastic surgery practices, and they can be pretty close together. So if you restrict an employee 10 miles and you're in Dallas, that severely limits to the practices that they could go. You're going to have to move to a suburb and move your family and move schools. And so maybe something that exceeds 10 miles wouldn't be considered reasonable here. You might be looking more to the 5-mile range. But if you're in a more rural area and all of the practices are few and far between, you could justify a 50-mile radius if that's what was found to be reasonable in your area. So again, it all depends. Then one very important piece to having this enforceable non-compete is that the employee must be given consideration at the time that they sign their non-compete. One very easy way to meet consideration is to have the employee sign their employment agreement at the start of employment, and it has the non-compete within the employment agreement. So the consideration there is employment. And so it's like, again, another easy check. Where that gets difficult is if you decide to provide all you want, you make it a new practice policy, and every employee is going to sign a non-compete, whether you're new or current. It's those current employees where you might have a little bit of an issue with consideration. And the states do define consideration differently, but it's very, very rare for continued employment to be considered consideration. So ways in which you could justify consideration if you want to impose a non-compete mid-employment. Did they recently get a raise? And so that raise, increase in salary or increase in duties, that could be a justification for consideration. And lastly, a court is not going to enforce a non-compete if it is against public policy. This is where we see those limitations for certain professionals like physicians or nurse practitioners and physician assistants. Physicians having certain limitations for an employer to enforce a non-compete, it's all related to the public policy aspect of, they're rendering medical services. They have to be able to treat the community. You don't want to interfere with someone's ability to make a living that way, especially when they're rendering that type of service to the public. So we do see a lot more limitations as it relates to physicians, but we are seeing a growing trend of those similar limitations being applied to PAs and NPs as well. So with all of that being said, and I think everyone has a great intro to the general concepts of a non-compete, we're now going to get into the FTC rule. And before we get into the FTC rule, we'll just set the stage with the FTC. Who is the FTC? What's their jurisdiction? What gave them the authority or the ability to come in here and make this non-compete rule? So the FTC, it does stand for the Federal Trade Commission. And the FTC from themselves, I'll say first that they do have jurisdiction over the unfair methods of competition or any unfair or deceptive trade practices that are in or affecting commerce. So that is their jurisdiction. And when we say in or affecting commerce, that simply just means across state lines. And so with that, with having the ability to have authority over those practices, this allows the FTC to one, they can determine whether a certain activity is going to fall under that umbrella of in or affecting commerce, and they can determine if that's an unfair trade practice. And then if they determine that, they then have the authority to write the legislative rule. So that's how we came to be where we were with this non-compete rule. And kind of an overview of the life of this rule. I don't know if anybody remembers, but it was first announced or proposed what feels like forever ago, back in January of 2023. And it wasn't until April of this year that they finally announced the rule. They'd written the rule. It had gone through the commentary process and the opinions. So in April of this year, and that's when I feel the industry was shook a little bit, because it was just published. Oh, the final rule is out, and once it's published in the Federal Registrar, that's it. It's going to be implemented nationwide. So from when it was published and we understood what the rule was going to say in April, the FTC then did publish the final rule in the Federal Registrar. And what that meant was, from the date it was published, it would be in this just published phase until 120 days. So the effective date was set for September 4th of this year. And that's really what the significance of that was. And I think that's why it disrupted everyone a bit, because from that moment, that's all we were reading, like, oh, the rule is here and it's going into effect. So let's, before we move on, really understand what the rule said, who it was going to apply to, and I think everybody kind of understands the general aspect of the rule. And it was written in a way to ban all non-competes nationwide. They were no longer enforceable. It was that non-competes were a no-go. And it was applying very broadly. So not only was it applying to employees, but it was covering independent contractors, any externs or interns or any volunteers. Like I said, it's nationwide, very broad in scope, and it was going to change the industry with all of, employers such as yourselves that had what seemingly felt no way to protect their business from competition. And there was, during that rulemaking process, there were a lot of conversations on whether physicians and other healthcare providers should have been exempt from this rule, meaning that an employer could enforce a non-compete against them. And that went through a lot of back and forth, but there were so many healthcare agencies that really just lobbied against creating that exception for physicians. And so all that to say, the FTC did not include an express exception for physicians. However, there was one listed exception that could possibly apply to physicians if they met the criteria. And that exception was the senior executive exception. And like I said, this was something that could possibly apply to physicians, but depending on the role of the employee, it could apply to several other providers. But us looking from the healthcare space, we can see why a physician might meet this criteria. So I do have it up here on the slide, and there were 3 different avenues that they could possibly meet. But if you're reading along, and I know it's kind of a lot of words on the screen, but they're all kind of saying the same thing, but the different criterias are meant to capture different employees in either their promotion or demotion, or if they left a year before this went into effect. So it could capture those individuals as well. But really, when you're looking at it for a physician, you're thinking, okay, the first thing I have to check off the list would they meet this salary threshold? And that's kind of the first piece for everyone. And the salary threshold is set about $150,000, and most physicians are going to meet that threshold, and you likely are going to have some PAs or NPs meet that threshold as well. So once you've hit that piece and the analysis, you then go on to determine, because again, it's the senior executive exception. That means that this person is in a policy-making decision that makes them this quote-unquote senior executive. So they'd have to fit into a role like that as well. And for the physician, it could have possibly been a president, a vice president role, a CEO role. But even if there wasn't a title, if there was an argument that this physician was in such a position that they were able to make those policy decisions for the business, this exception could have worked as kind of a workaround of that. So we have the rule, we knew what it said, we knew the exceptions, and we just kind of had this pending date of September 4th. Well, on the exact same day in April that the FTC published the rule, there were several businesses just gearing and ready to go to file a lawsuit to essentially put a halt to the FTC final rule. So as I said, this was actually just a day after the U.S. Chamber of Commerce, together with several other business groups, they filed a lawsuit against the FTC in a Texas federal court in attempt to like I said, to overturn this rule. And really their argument to kind of get that through the door is going back to not even, they went first to just the FTC's ability to do this. They were saying the FTC certainly lacks the jurisdiction to make this type of rule because, one, they have jurisdiction under unfair methods of competition. Not all non-competes are going to be determined or decided as an unfair method of competition. And they really firmly believe that this concept of non-compete should remain with the states as it always has been. And so with that being said, like we said, timing couldn't have been better. So at the end of August, we actually received a ruling from this court case. And I'm getting ahead of myself here, but we kind of went over all of this, how the FTC lacked their authority, should be governed by state law. And as I said, in the last week of August, we did receive a ruling. So this federal district court in Texas, they struck down the FTC non-compete rule in its entirety. So the non-compete that was to ban, or the rule that was to ban non-competes nationwide, struck down. And from this, the court, how they came to this decision, they did rule. They sided with the business entities and the Chamber of Commerce that the FTC had in fact exceeded its statutory authority by trying to enact this rule. And so going back to a little bit of civil procedure and legislative procedure, there is an act called the Administrative Procedure Act that allows these courts to continue to review these actions and these rulemakings that are published by agencies such as the FTC. It's a little bit of checks and balances that they have in place. And so what the court was looking at was, did the FTC as an agency exceed their authority? And what they're looking at when the court makes this determination, they're trying to determine if this ruling was arbitrary or capricious or an abuse of their discretion. And if they find that, they can deem it unlawful and just completely set it aside. And That is what they did here. They ruled that it was arbitrary and capricious, and it was so broad. As we were saying, it covered all non-competes over all employees. They did have that limited exception, but if a rule is meant to target harmful non-competes, it doesn't necessarily make sense to ban all non-competes. And that was one of the court's reasons for striking it down. They said the FTC really didn't give an explanation behind their reasoning to ban any and all non-compete. And they didn't, the FTC also, they didn't provide many alternatives to this either. And so it was way too broad. The court could not uphold this. And so with it being held to be unlawful, they set it aside. And so what are we doing here? What does that mean for us? It does mean, as of this date today, non-competes are still governed by state law. So I'm not saying the overarching statement of non-competes are enforceable, because state law, that's not always going to be the case. I do want to note the FTC does have the ability to appeal this decision. So that is possibly in the works, or they may not, but they do have the ability. So this may not be the last that you're hearing from me. Maybe in a couple months, I'll have another update. But right now, we're going to focus on non-competes and the state statutes or regulations. And so that's kind of how I want to take this next half of our time together, is to get into now a little bit more of the nitty-gritty and what it looks like implementing a non-compete in your practice and what's going to be most helpful for you. So non-competes in the aesthetics medical industry, they can look a little different, as we noted in the beginning, because of the public policy aspect. And while there are still various states that allow for non-competes, there is a trend of seeing more restrictions as it applies to physicians, physician assistants, and nurse practitioners. So I think it's very important to be aware of that and to make sure before you do enforce a non-compete against those individuals, you understand your state law. So with that, Byrd Adatto has created this very handy, nifty state overview of non-competes. And you can see we've divided our states into 3 different categories. Orange being those states where, yes, it's enforceable by law, as long as you meet those general requirements that we talked about at the beginning of our time today, you are good to go. No crazy limitations or restrictions, just make sure you're meeting those general requirements. And then you'll see we have those dark blue states. Those are the states that it's a no-go for non-competes. And I'm sorry if I didn't say this before, this map is focusing on the medical aesthetic space as well. So there could be states in which, like, there are enforceable non-competes. I'm going to take Colorado for an example, and I'll get into the specifics of Colorado later on too. You'll see that Colorado is a dark blue. Physician non-competes, not allowed. There are non-competes that may be enforceable in Colorado, but we're looking at physicians on this map. And so this map can also be found on our website if you have questions about your state. So if wherever you're sitting right now and you see that your state is dark blue and you want to talk about that more, always happy to chat. And then the light blue are those tricky states that could possibly have an enforceable non-compete, but there are going to be strings attached. It's not going to be cut and dry as those orange states were. You're going to have to possibly get a little more crafty, or you may not be able to apply those non-competes to all of your employees. So like I said, I want to take a few of these states just as an example to highlight to you what you might see when I talk about those special requirements or those special limitations and what that might look like. And I chose, of course, Texas because I'm in Texas. I have to, give my state a shout out. And I already kind of introed, we're going to also talk about Colorado. And then we're going to also talk about Connecticut. Connecticut has some newer statutes that have been implemented. So I think it'll be, in my opinion, fun to cover some new aspects of the law. So let's again start with Texas. Texas has a very specific statute. It can be found in the Texas Business and Commerce Code, 15.50. If you're interested of ever looking it up on your own. But what's great about this statute, and I'll say it's so helpful on our end too, when there is a statute that gives us clear guidance. That way you can be a little bit more confident in your non-competes when the state has specifically addressed it in that way. So the statute starts off by covering those general non-competes, and you can see they are aligned with what we already covered. And that's going to apply to every employee other than a physician. When we get to the physicians, this is where maybe some creative drafting or employment agreements are going to be very, very relevant for your physician. And what's different about a physician non-compete, it still has to have every single requirement of a general non-compete, but then you'll want to have language in your employment agreement that goes through these other very specific requirements. And these are outlined by statute. So for you to be able to enforce a non-compete against a physician has to be in the physician employment agreement, or the point is kind of moot. So here, it must clearly state that this restrictive covenant is not meant to deny access to the list of patients to who the physician treated for that previous year. So looking at the date of termination 1 year previous, they are able to have access to the list of patients. This is really related to continuation of care, or if a patient reaches out and they want to continue their care with their physician, you can't restrict their ability to do that. That also could be related to certain, malpractice claims, or if they're going through like a board certification process, they should be able to have access to those patient records. And then again, too, if, like we were saying, say your physician leaves, and oftentimes too, some physicians have very specific patient notification requirements. If they leave a practice, they have to notify their patients, and that gets a little gray with solicitation versus just notice, but we won't get into that today. But from that, patients can decide to follow their physician. So if a physician needs patient records, you can't deny them that if the patient chooses to go to them, but you can charge a reasonable fee for copying and providing those records, just as you would with anyone else. And then this is a very important, this buyout provision. That is where if I get a physician employment agreement in Texas and they want me to evaluate it and review it, that's where I go first. If I don't see a buyout provision, and it's a buyout provision of the restrictive covenant. So the non-compete, and depending there, it's more of a gray area of whether or not the buyout provision applies to a non-solicitation, but we are certainly sure that it applies to the non-competes. And sometimes, to be safe, you capture those two together in Texas. But the buyout provision must be in there to allow this physician to buy themselves out of this non-compete. And the way the statute is written is that this buyout provision must be a reasonable amount, which is about as vague as it gets, or the parties can negotiate and decide on that value themselves. I'll say the insider scoop of a reasonable amount is typically going to be 2 times their annual salary. And they have to pay it up front. So it would never be anything as low as, like $10,000 would be like very, very low, because you don't want it to be easy for them to buy out, but you gave them the option, and 2 times their annual salary is typically seen as reasonable. And lastly, nothing in the agreement and the covenant cannot restrict them from providing the continuation of care. Sometimes with the aesthetic space in the plastic surgery space, it can be very limited. It's not really the same as your family practitioner or a general practitioner or someone in another specialty that has that ongoing care. A lot of times it can be a surgery, you had follow-up, see you next time when you need another separate service. That continuation of care is very much related to the specific treatment. So that's something that's a little bit different, just with the space that we're in. So that is Texas. Most people in Texas are quite familiar with this. So it's typically in all non-competing, all employment agreements. And when it's not us ourselves, we kind of question who might be on the other side. But so that's Texas. And then Colorado, we already touched on Colorado when we were looking at the map. So the overarching piece is physicians, it's not enforceable. A non-compete is not enforceable. But that's not to say that you can't, there's a little bit of workaround in the statute, but not really for an explicit non-compete. You can still have other provisions that require a payment of damages if it was reasonably related to the termination of the agreement. So what that language is all meant to say is you can still enforce like a liquidated damages provision. So if a physician leaves before a certain time, you might have a liquidated damages provision, just depending on who they are, what training you brought in, that could justify at least something to entice them to not leave within a certain amount of time. But as far as non-competes are concerned, again, it's a no-go. But for everyone else, if we're looking at PAs, NPs, and possibly RNs, non-competes may be enforceable. This is one of the states that has implemented a salary threshold, and we've seen this in other states like Illinois, for example. They have a salary threshold as well. And so anyone who is not meeting that minimum salary threshold, no non-compete. That's why I mentioned possibly RN. So when Colorado put this law into effect, which is in 2022, and so their statute includes the amounts that were in place in 2022. I'm sure they've increased just with the inflation at this point. But in 2022, the salary threshold for a non-compete was around $100,000. And then for a non-solicitation, so this was interesting too. Some states like to only address a non-compete, and they just leave out non-solicitations for us to just wonder how they're meant to work. Thankfully, Colorado addressed non-solicitations, and so the statute applies to both, but they have different salary thresholds. So the non-solicitation in 2022 was around $60,000. So more likely you're going to see like an RN or an esthetician possibly with a non-solicitation, which is still great to be able to include that within their non-compete or within their employment agreements. But really for Colorado, you're looking at your PAs or NPs. With that, they also have very specific notice requirements. So the notice requirements entail the timing is going to be different, like we said at the beginning when we're looking at consideration as well. It's different for your current employees and your existing employees. A new employee and your current employees. So a new employee must be provided notice 14 days before their start date. Easy, not a huge issue. It's with those current employees that, again, create a little bit of the issue. And the way the statute is written, so for a current employee, the notice must be given to the employee the earlier of either the effective date of the restriction or the effective date of any additional compensation in exchange for the change of terms. So this, again, is trying to capture that consideration piece. So it's whichever those dates is earlier, but you still have to have consideration. So they say the earlier of the date that it goes into effect, but you still have to have consideration, which is probably going to be an increase of salary. So it's just before that date. But this notice, not only do you have to provide it, but the statute's also very specific on what the notice must look like. It has to be in a completely separate document. The employee is going to have to sign it. They're going to have to give their acknowledgement that they even received this notice. It has to identify the agreement. So it's going to be probably, physician assistant employment agreement, nurse practitioner employment agreement. The notice has to state that it contains a non-compete or non-solicitation. It has to also point out the specific paragraph to where they can find it. So it's just a notice that's going to cover all of those bases. And in addition to that, you have, like I said, you have to give them the full agreement along with the notice as well. So 14 days. What's very different about Colorado, and we don't typically see this because a lot of conversations that we've had for employers that are in states that they know they don't allow non-competes, taking like, California, for example, sometimes it's, even though they know they can't enforce it, they still want to put it in the agreement just to act as a deterrent. You can't, when they leave, you can't send them a cease and desist and say, oh, you have a non-compete. It's because it's not enforceable. Well, I guess you could, but after that, that's kind of where your story ends. And so sometimes you do take that route, even though you're very well aware it's not enforceable, but it still could stop someone from practicing 5 miles down the road or 3 miles down the road, because a lot of conversations I have with employees as well is, oh, I have a non-compete, I can't go there. But then I take a look at their non-compete and I'm like, oh, this isn't enforceable. But a lot of employees don't know that, so it still can act as a deterrent. You cannot do that in Colorado. There is a penalty in place for it's a civil penalty, a monetary penalty, about $5,000 per violation. If you attempt to enforce or put a non-compete in an employee's employment agreement where you know you haven't met the requirements and you know it's not enforceable, that's a violation and you'll receive that monetary penalty. So that is, like I said, something very new and different. We don't see that too often. And lastly, let's get into Connecticut. So the Connecticut, I would say in last year, fall of 2023, which is still pretty recent enough to where the bill that was passed into law, it has not been updated in the actual statute. So if you go look at the statute, you don't see these updates, but there is a bill that has been passed. And so, the law is always behind, but it'll get there. But regardless, we're here to talk about, because it is in effect. So any agreement after, let's say, October 2023 must be governed by these restrictions. And one very important piece to note is that for physicians, and it's very specific to physicians, physician assistants, and nurse practitioners, a non-compete must be part of an employment agreement. There are some states where the language says the non-compete must be part of an otherwise enforceable agreement. Texas is one of those states. That just means it has to be it can be a different form of an agreement, like a non-disclosure agreement that was given on employment. That meets that criteria. That or just a general agreement that covers non-competes, non-solicitations, sometimes that can work. Connecticut, it cannot. They have to have an employment agreement in place. It cannot exceed 12 months, and the geographic scope is limited to 15 miles from where the provider specifically renders services. Oftentimes, we'll draft a non-compete that for a practice that has various locations across the state or in various states, and the non-compete is drafted to cover a 15-mile radius of any practice location. You can't do that in Connecticut. It has to be where their primary practice is. So they're narrowing it down to the one location. So it's very important as well. And then also, as far as it goes for the enforceability, you can only enforce this non-compete against the employee if it's the employee who terminated their employment, or if the employer had to terminate their agreement for cause. So that lends itself into several other conversations that you're going to have when you're drafting an employment agreement like this, because typically an employment agreement has, for termination, you can have either party terminate without cause. You just likely will give about a 90-day notice. So without cause. If an employer terminated you without cause, no non-compete. But that's why it's very important to make sure that your for cause provisions are drafted in a way that can capture an employee that's possibly gotten you in a sticky situation, and you don't, you want to have the for cause there available to you. So that all lends itself to your conversations and when you're drafting your employment agreement with your counsel. And we've been talking a lot about agreements, employment agreements, and I've been making it sound like you cannot have a non-compete enforceable if you don't have an employment agreement. That is not necessarily true. As as you can all probably guess, it's state dependent. And like we were saying with Texas, just using that as an example. And it also highlights where you might make that decision for yourself if you think an employment agreement is going to be helpful to you, or whether you just kind of feel like it's more trouble than it's worth and you can enforce your non-competes without it. So before I even get into that conversation with a client, my first question to them is, when they ask, oh, do I need an employment agreement? I'll say, do you anticipate your employees to continue to be at will, which means that you can hire and fire at any time you want. You can change their compensation anytime that you want. They don't really have that the job protection that you would with an employment agreement. Because what changes an employment agreement, it's seen as a sign of job protection, because your compensation is locked in for the term. Your employer can't change your compensation unless it's signed off by you in writing. And it gives, when I say job protection too, it's those termination provisions that we were just talking about in reference to Connecticut. You typically see an employment agreement with either party can terminate. And when you're dealing with a mid-level or a physician, we see that termination period of notice being like 60 to 90 days. That's pretty standard. For RNs or estheticians, depending on your practice, you can see that from 30 days. There's pros and cons to both. Having the longer time period is great because that way you can find a replacement for them. But sometimes what happens when you include a longer termination provision, it's just they leave and you're like, I'm ready to be done with this employee. It's not working out. And so when you have that 90-day protection, you as an employer, you can let that employee go same day, but where you're caught, you owe them 90 days worth of pay. So it's just a kind of conversation you have to have with yourself there. And so that is the conversation that I have with my clients. It's like, do you want to enter that realm with this employee, or do you want to keep them at will? And they could say, I want to keep them at will. I say, that's great. My next question for you is, do you want to enforce a restrictive covenant? They say yes. I do typically push them towards an employment agreement, especially if we are dealing with the physician or mid-level. It's pretty much, I'm going to say yes every time. With estheticians, and depending on your state, you might be able to get it in just a typical like non-disclosure agreement, and that's what they sign upon employment. Again, that's where, I can't stress enough how important it is to have a policy in place. That way, when you hire new employees, you're ready to go and you don't have to worry about implementing with your current employees. But as we've said, there are ways that you can do it. And so and ways you can do, like we said, you would just have to determine really what consideration would be at that time. So looking at the implementation, say you decided employment agreements, that's the way to go for me. I'm fine with the notice termination provisions, have my employment agreements ready to go. All of my non-competes are drafted in accordance with law. And you just had an employee, one of your top performers, leave and go to a practice 3 miles down the road, or they opened a practice of their own 3 miles down the road. So the first thing that you're going to do is you're going to pull out their employment agreement, look at their non-compete, say, yeah, their non-compete, it was a 5-mile radius. They are in violation of their non-compete. There's no ifs, ands, or buts about it. So Where do you go from there? How do you enforce it against the employee? It can go through a few different stages. And really, for the first step, we already covered it, is you're going to go back to their employment agreement always. You're going to get with your counsel will review, and they'll say, here is where they're in violation. We're going to send them a cease and desist letter. Before I even note getting into this cease and desist letter, before, we have some clients who will reach out and they know they're fully aware that they have an employee leaving, one of their top performers, and they have a feeling that they're going to compete against them in the mile radius. They don't know for certain, but they just have a feeling. What we do in that case is we'll send a kind of like notice of your obligations letter that is given to them on the day that they leave. So they're not in violation of anything. Your letter isn't accusing them of anything. It's just, hey, remember you signed this agreement. In this section of your agreement, you had a non-compete and you can't practice within 5 miles of my practice. Just to put them aware. Again, it's kind of a way to act as a deterrent. Whether or not they take note of that, that's where we now get to this cease and desist option. The way we typically send out our cease and desist is you want to send one set, you can send the same letter noting, and send a copy of the employment agreement. You send it to the former employee and you send it to their current employer. That's what your counsel will do. So, and just me say, have your counsel send everything. You don't want to personally be sending your cease and desist letters, but that's what we'll do. We'll send it to the employee and then we'll send it to their employer, because I'm sure you can all agree, if you received a letter and you found out one of your brand new employees was in violation of their non-compete, it kind of puts your red flags up and you start thinking, oh, this employee is in clear violation of their non-compete. I enforce non-competes. Are they going to do the same thing to me? And once we send that letter to the employer, like, that's it for us. It is completely up to the employer on what they want to do. And I will say, I have had an employer call me and just flat out say, okay, I'm firing them. Like, that was it. And that's not really there's a conversation of, was there like a job interference, but not really, because they had the non-compete and you're just putting that employer on notice. And so what they decide to do at that point is completely up to them, but it's all part of the process. Say you've sent the cease and desist to both the employee and the employer. No one pays attention and nothing has changed. They're still there. The next step to enforcing that is getting a temporary injunction with the court to stop this former employee for competing in violation of their non-compete. That's where you get into then the litigation route. That process of the injunction, that could oftentimes just stop an employee and they're like, this isn't worth it. I don't want to go to court to argue back and forth over my non-compete. But it definitely does happen. If you feel, and this is likely, I mean, most businesses aren't going to enforce a non-compete unless that employee leaving is significantly hurting your business. They took, half of your patients, or even more, a third of your, but it's a significant damage to your business. And if that can be shown and you have an enforceable non-compete, you're going to be in very good shape. But as we said at the beginning of today's presentation, it's all in the hands of a competent court. Every court is very, very different, and it's all going to depend on your judge. So sometimes, even though you have what you think is an ironclad non-compete, sometimes the court they'll end up striking it down and they don't enforce it. So that can come with a lot of the commentary that we all hear, and I'm sure you all hear as well. We've heard for years, even before the FTC ruling, that non-competes were not enforceable. Again, that is not a true blanket statement, but it is so case and fact specific once you get into kind of the litigation court system. And so you have to have conversation with your counsel, weigh the pros and cons, and just evaluate that on a case-by-case basis. But thankfully, sometimes the non-compete acts as a deterrent, and a cease and desist can do the trick. So that is all very important to keep in mind when you go down the enforcement route. And so with my last few minutes, I am getting close to wrapping up. I know we're pretty much at time here, but I don't want to leave out the people who are in our audience today who might have had a dark blue state and your non-compete is not enforceable. There are alternatives to a non-compete while it's not going to be in the same form of restricting in a mile radius. What we see most often, and where, because really when you think about it, the point of a non-compete is to protect your business and to protect your clients and to protect that information and everything you've worked so hard to develop. That can very easily be accomplished through a non-disclosure agreement. And the protection of your confidential information. This can also be worked into your employment agreement, or it can be a standalone agreement. The key to this and where it works in your space and where we see it most often being enforced, and I'll kind of paint the picture of what it looks like. And it's very similar. You have a top competitor leave and they take their patient list. They've been reaching out to everyone on social media. They've been contacting them. You have very clear evidence. Patients have told you, hey, so-and-so reached out to me. I don't know how they got my number. Like, you start hearing patient stories like that. But that provider, they didn't have a non-compete. So they were like, oh, I can do as I wish. I can take any patients that I want. I can reach out to any patients that I want. I don't have a non-compete. I don't have a non-solicitation. Your non-disclosure agreement is protecting confidential information, proprietary information, and your trade secrets. All of those are very broadly defined to capture protocols that have been developed by your practice, but most importantly, confidential information includes patient list and patient information. So when someone who doesn't have a non-compete and they don't have a non-solicitation, but they have a signed non-disclosure agreement, by utilizing those patient list and that patient information, they're in direct violation and they are using that information in an unauthorized manner. So that's a great way for you to still have, I guess, a little skin in the game as it comes to restrictive covenants, and they are very, very important. It's something that I think should be part of every employee onboarding, is to have a non-disclosure agreement in place, because it really can work as a catch-all in a lot of circumstances, just as this. So like I said, I didn't want you all to feel like nothing was available to you, just because you can't join the non-compete gang. But so really that is kind of all that I have. Like I said, I've really enjoyed being with everyone today, and it's kind of time for questions. I'm a huge Office fan. I don't know who isn't these days, but